This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Welcome to Beyond a Reasonable Doubt with my co-host, Gary Patrick Smith. How are you, Gary?
I'm well, Mark. How are you?
I'm excellent. I'm in Miami, coming straight to you from the National Trial Lawyers Conference.
Well,
So,
I think there's
I'm walking around.
I think there's only one thing that the audience wants to know. How was the lamb?
Oh, my God. The riblets were unbelievable. So thank you for remembering.
Absolutely. I'm very glad and I'm jealous. Here in California, not so many opportunities to dine normally.
I will tell you, last night my daughter took me to a place where I swear to you, there were women dancing on the tables. And I said, wow, I almost forgot that there was a pandemic. So,
well, in Miami, I absolutely believe it. But all joking aside, the big story of the last day or so, this releases on Saturday, but the big story of Friday morning, we've opined about it for weeks, the federal indictment of the 4 officers in the George Floyd case.
Right. And I will tell you, as we have been talking, anybody who listens to this, they were ready, at least if you believe the reports, to indict Chauvin the minute if he had been acquitted. Well, as we've discussed, there was no chance of him being acquitted. I think that the timing of this is very, very unusual in this sense. He's already been convicted. The other 3 officers obviously have a trial that's coming up in August on the state court side. This is a federal indictment. They've already made their appearances. It doesn't look like yet that they've transferred the custodial arrangement to the feds on Chauvin's part, and they allowed the other 3 officers to continue on, at least so far, on their current status on the state side. The reason this is interesting is they waited until after the motion for new trial. They waited until after this picture of one of the jurors surfaced. It's interesting to me tactically what the defense will do here. The defense could say, look, Judge, I don't want to have my motion heard now. I want to focus on the federal indictment. There are speedy trial rights. Pre-COVID, I opined before, under the COVID Constitution, the writ of habeas corpus has been suspended. But traditionally on the federal side, you've got a 70-day window to go to trial. Arguably, they may want to go into federal custody and deal with, or Chauvin might, and deal with the federal matter. The thing that's looming over him is not only did they indict on this incident involving George Floyd, but they also indicted Chauvin on a 14-year-old boy as another incident from 2017.
Correct.
Which, by the way, that will, that if it's part of the indictment, that puts into play some serious consequences in terms of a conviction and sentencing. Because it's a minor. You might remember that was one of the reasons on the state court case for allowing in some of the evidence surrounding the bystanders witnessing this, because the argument was that there was a minor and that the minor was affected by seeing this, and therefore that would be what's called an aggravating factor. This prosecution of Chauvin, and now the double prosecution of Chauvin, is really kind of a law school or bar exam question on criminal procedure and criminal law. There are so many nuances here. And for those who are wondering, it's already been ruled upon that it's not double jeopardy, but arguably there could be an argument for double punishment. And I'll throw it to you for you to react.
Yeah, absolutely. I guess first let me ask a question that came to my mind not before we recorded, but while you were explaining that. You said there's a 70-day in the pre-COVID world, and I won't get you started on speedy trials. I know that will send you just straight through the roof.
Right.
But let's assume that the 70 days is in place. Squarely in the middle, if my math is working correctly as I speak to you, squarely in the middle of that 70-day window is when he's going to be sentenced on the conviction in the state court. So how might that impact the federal charges and the trial that would unfold thereafter?
he could ask for, the defense could ask for the judge in the state court case to hold in abeyance or stay that matter pending the federal matter. He could say, look, we've now got jeopardy from the feds. We don't want to have do anything that's going to jeopardize or further complicate matters. And the defense may say, we want to stay. Or the prosecution, it'll be interesting to see, and whether it comes out, how closely the state court prosecutors were working with the feds. If they were working hand in glove, there may be an argument there that the defense is going to make at some point in terms of the timing of the indictment and how that impacts the state court case. Somebody could also speculate that this, the judge himself, Judge Cahill, might on his own or seek briefing from the parties as to what the impact is on having a sentencing hearing on the pretrial rights of the defendants in his case. Because remember, Cahill still has the 3 defendants on the state, and their trial is smack dab, at least now, set in August. So that complicates matters too. I'm going to guess that if you had Judge Cahill on the bench today, and he heard about this indictment before the 3 officers went to trial on the state court case, that he would have some indigestion, because this also gives him yet another complicating factor.
Right, because now he's under the scrutiny of, how it's will impact or is impacted by the federal charges. So I thought...
Correct. I mean, can you imagine picking a jury in the middle of this for the other 3 officers after all of the publicity of the Chauvin trial, and now that you've been indicted by the feds before the trial of the other 3 officers? At a certain point, he may just throw his hands up and say, I'm going to let the feds take the jurisdiction of this, and I'll see you after the whole thing is over. That
would make the most sense to me. I mean, it's already been, a bit of a circus, what with the settlement right before, in the middle of jury selection. He's just, I would have a headache if I were him. So that would make sense to me.
Well, you take a look at what he's got on his plate here. He's got a motion for new trial. He has this issue that I'm sure he's seen about in the media that was obliquely referred to in the motion for new trial of the juror with the T-shirt. He's got the $27 million settlement you just alluded to. He's got Maxine Waters. He's got the president saying, well, the jury was sequestered, but the president commented anyway. All of those things are fair game for the lawyers for the other 3 who have not gone to trial yet, who have now been indicted by the feds as well.
Yeah, absolutely. And let's not forget that he overruled the motion for a change of venue, which is probably going to come up, especially after the unrest broke out, and not really related to their case, but at the same time, just miles away where jurors were living. It's a nightmare.
Well, they're right. There was one juror who actually has given an interview, albeit it might have been an alternate, saying that she lived in that town and was watching it from her balcony. And during the trial.
Yeah, and she was concerned, all right. That's absolutely, it's just a nightmare. Well, the indictment that was unsealed named all 4 of the officers, Chauvin, Lane, Kang, and Thao, and specifically Chauvin is charged with violating Floyd's right to be free from unreasonable seizure and unreasonable force, where the other 3 are charged with violating his right to be free from unreasonable seizure. How exactly do you think that the difference in those charges will play out? Obviously, Chauvin is working under the circumstances of already having a conviction, which they will build off of, whereas, Adam alluded to kind of the other 3 cops in the last episode and how possibly the trainee, brand new on the job officers might be in somewhat less jeopardy than the guy who had been on the force for 6 or 8 years, but still in quite a bit of trouble given the sort of political and societal nature that we're dealing with today.
Well, one of the other interesting things here is you've heard me talk about qualified immunity, and right. I've been in this battle about qualified immunity in the civil context where we sue the officers for something that they have done, and just yesterday, there was a ruling on qualified immunity on a fairly outrageous case I believe, in the Ninth Circuit. Outrageous in terms of the fact pattern and the fact that I believe it was a 13 or a 14-year-old who was coerced into confessing, and it turned out that he was innocent, and the cops were given qualified immunity. Now, those are intentional acts. So if you're cloaking the cops in qualified immunity for intentional acts, for the people have heard me talk about the case in Arkansas, where the officer told the young boy who had the gun to his head, stop or I'll shoot, and he started to, or drop the gun or I'll shoot, and he started to drop the gun, and the cop ended up shooting him. And that was at the district court level dismissed, and the circuit court reversed it. I'm actually, as an intellectual and constitutional exercise, this indictment in a kind of almost ironic way may be what provokes the repealing of qualified immunity. Because if you are indicting officers for violations of people's constitutional rights, for stuff that if you sued them, most circuits right now would probably say the officer has a qualified immunity, then the question is, this points out how crazy qualified immunity is. You're telling me that you can be criminally prosecuted, but you have civil immunity? And so I think there's some real constitutional issues here, and this may be what sparks the repealing and the long overdue repealing of the judicial creation of qualified immunity.
I think that would be a good thing, even if it comes out of a horrible situation. It would be great if we could find some positivity out of all this in the long term.
All this stuff. Exactly. And so before next Tuesday, when you and I meet again, I will give that some further thought and see what we come up with. Now, and Gary, thank you, by the way, for accommodating me today.
Absolutely. Before we wrap, I just we alluded to it a little bit, but how do you feel that the Chauvin 14-year-old incident from 2017 is going to play into this? This is an incident where a 14-year-old who Chauvin described at least as 6'2" and 240 pounds in his report. The facts in the case seem to indicate that Chauvin choked him, then held him to the ground, put his knee on his neck and back. There's conflicting reports that he was hit with a flashlight and required a few stitches on his ear. How do you think that case will play into all of this for Chauvin? And will the fact that Chauvin was charged with this at the same time have any impact on the other three officers' case and defense?
Yeah, I think that plays right into the defense for the other three officers. And it's a right for cross-examination. When they put the chief on the stand again, or if they don't, I would call the chief and I would if I'm one of the lawyers for one of the other three officers, you're going to cross-examine the chief. Oh, really? You were cleaning up the department? Oh, this isn't the way it was trained? Well, then how in the heck in 2017 did this officer escape any kind of punishment, meaning Chauvin? And you're now putting him out there to train these officers, one of whom was on the force for minutes, and 2 minutes. Right? Two of them
were on the force for about a week.
How are you going to justify prosecuting one of these guys who's getting trained when you didn't do anything of any great moment, and you put that same officer Chauvin in charge of training these guys? It's to my mind, be careful what you wish for. It's obviously an aggravating factor and a sentencing enhancement. Ultimately, at the end of the day, on Chauvin, if convicted, but at the same time, it really gives a window of opportunity for the other three officers to make a compelling argument.
Yeah, as I slightly alluded to when you and Adam were together, I really, if I'm these officers, I'm Chauvin, I feel I'm just completely screwed and I'm in the worst possible situation. If I'm the guy who's been on the force for 6 or 8 years, I'm really not feeling good and I'm feeling screwed. If I'm the other two, I'm not feeling good, but I'm feeling like I at least have a defense that I can help an attorney get ready that can lessen the situation, if nothing else.
And by the way, from Eric Nelson's standpoint, he didn't want to bring that 2017 incident up when cross-examining the chief because it was fraught with all kinds of problems. But now it's in the indictment, it's square there, and it's the subject of cross-examination. So I'm fascinated to see how that plays out.
It'll be very interesting to see how it comes. Mark, thank you so much for the time. I'd like to remind everyone that if you would like to watch this episode, and a professional probably would have done this at the top, but if you'd like to watch this and future episodes of Beyond a Reasonable Doubt, those are available exclusively on the Reasonable Doubt YouTube channel, which is youtube.com/Reasonable Doubt Podcast. We put the Saturday shows up on Adam's channel as well, but the only place that you can get the Beyond episodes on YouTube is youtube.com/Reasonable Doubt Podcast. Mark, thank you very much. Have a great day. Mahalo.
Bye, Gary.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.